Like several other states around the country, Massachusetts is seriously rethinking the costs and benefits of mandatory sentencing and incarceration. In many cases, the gains for public safety have been diminished by the growing cost for taxpayers, and there's concern about the ripple effect of incarceration, reinforcing cycles of poverty and violence even in some of Boston's neighborhoods. These are among the factors behind the wide-ranging reform bill recently advanced by the state Senate. Joining us is the Senate Chair of the Joint Committee on the Judiciary, Senator William Brownsberger. Thank you very much for being with us, Senator.
So glad to be with you. Thank you.
First of all, talk about the things that are driving this reform movement. It's not just in the State House and senators and reps. This is a very community-based push that's going on as well.
No, there's a broad conversation about the reality that in Massachusetts we are locking up 4 times as many people as we in Massachusetts were locking up 40 years ago. Something really has changed in our state, and that those effects, that incarceration is especially concentrated in neighborhoods of poverty. And so in those neighborhoods you have a place where, yes, crime is a problem, but incarceration itself has become a problem. Moms and dads absent, people coming back into the community with no real prospects for employment and all the sort of disabilities that come from having spent a long time locked up. So it's a very harmful thing in itself. The other thing that's going on, and this is something that doesn't get as much direct focus, but I think it's actually almost bigger because it affects so many more people, is the entanglements that people have with the criminal justice system. The fees, the fines, the driver's license consequences, the criminal record consequences. They make it very hard for people to move forward and get back up on their feet and get housing and employment.
Well, one of the other things that's going on, and maybe this is not as controversial, but some of the things, the tripwires that send ex-offenders back to prison a lot of the time, these are not so much crimes as either they don't pay their fines or there's some kind of probation violation. Talk about the tripwires and what your legislation would do about that.
Well, there's a number. One of them is the fees and fines, and particularly, so people coming out of prison today, we charge them. So this is somebody, let's say they've been in prison for 10 years, they're very unemployable. We charge them $80 a month for the privilege of being on parole. Now that money's not going to come from their pocket because they don't have any income. That's going to come from their friend's pocket, their mother's pocket, their grandmother's pocket, their girlfriend's pocket, or they're going to go back to crime to try to cover that. So that's a very unhealthy dynamic. That's one of the things we do is we get rid of parole fees in this bill. Then there's all these sort of cycles that connect the registry of motor vehicles to the court system. So for example, you have a court case for whatever reason, you miss a court date, then as a result, lo and behold, we suspend your driver's license just for having missed the court date. Well, then maybe you don't know about that because maybe you moved and you don't get the notice and your life is a little bit disorganized. And then you're driving without a license and you get in trouble for that. And now you have a new court case. And people spiral downwards in that, and the fees, each time the fees are mounting up because of the various offenses, so you can never really get your license back. And so people keep driving because they have to work, and that spirals downwards. And judges in the system have seen it happen many, many times.
This has been in the news, and we're talking with State Senator William Brownsberger. Senator, this is mainly, of course, about mandatory sentencing. And talk about which population is going to be changed by this bill if it were to pass.
Well, you know what, I always push back just a little bit when people say this is mainly about mandatory sentencing, because there's about 10 different things that happen in this bill. It's just mandatory minimums is the one that's gotten the most attention, but I think there's a lot of things that are going to have more of an impact. But the mandatory sentence, I don't want to downplay. I think it's a very important change. So if you think about the business of drug dealing, it's like any other business. There's customers, there's retailers who sell to the customers, and then there's wholesalers who sell to the retailers. In the drug world, we call the customers users, we call the retailers dealers, we call the wholesalers traffickers. And what this bill does is say, look, we're really concerned about the traffickers. In fact, we actually increase the exposure that people's wholesaling synthetic drugs like fentanyl, which are the ones that are killing people most. So we're not backing off an inch on traffickers of the opioids. But we are saying, if you're just a low-level dealer, many of those dealers are users. Many are not, to be clear. But whether you're a user and you need treatment, or whether you're a low-level dealer just getting into the business and we want to divert you into something else, that's what we're trying to do. So we repeal all the mandatory minimums that apply at the retailing level.
And of course, one of the things I've heard from DAs over the years is that it's hard to get this firewall between the violent, drug agent, as it were, and the nonviolent. But what do you see? What's the reality that you see out there?
Look, I don't dispute. I think the DAs are right when they, there is a relationship between drug dealing and violence, but that's why we want to get people out of that cycle. I mean, people, if you're a drug dealer and you're carrying a lot of valuable stuff around and you're in a rough neighborhood, yeah, whether you have a lot of cash or a lot of drugs, you're very likely to have a firearm involved, and that just happens. But we want to get people out of that cycle. So we're not trying to say that these kids aren't in a bad place. They are. Let's get them out of that place.
Of course, the other way mandatory sentences are used is not as a reality, but as a threat. DAs use that. They do some plea bargaining, and they can often get defendants to plead guilty to lesser charges. You're going to diminish that somewhat. So what do you think the outcome is going to be?
Well, what's going to happen is it's really just a balance of power thing between the judges and the DAs. It's not a magic, huge increment. Because the same kind of conversations can happen between a defendant and a judge. The judge is going to say, well, he wants to plead guilty today. Yeah, we could probably do that for you. Or after trial, it's probably, very likely will be a different number. So the plea bargaining process is one that's got three players: the defense, the prosecution, and the judge. This basically just shifts the control a little bit from the prosecutor to the judge. In all cases, they're going to still continue to have a role in that process.
Of course, another thing this legislation looks at is that divide between juvenile crime and adult crime and the consequences. How would you change that? So
this is a very significant thing. The bill proposes to raise the age of adult, of criminal majority, from the age of your 18th birthday to your 19th birthday. So today, if you haven't had your 18th birthday yet, then you are a juvenile. For the purposes of criminal justice, you get handled in the juvenile court. The doors are closed. It's confidential. The record is basically sealed for most employment purposes, and you're likely to be placed in DYS, which is actually a very good environment right now. We're doing a very good job in DYS, and people come out of there with education and supports. Sometimes they want to stay involved in DYS because it's the only family they ever had in some instances. So DYS is a very good place. We want to include the 18-year-olds, include those who have not reached their 19th birthday in that DYS cycle. Those are all kids that are, of the high school age. Let's keep them in that cycle.
There's one other issue this bill looks at, which is a very disturbing issue, and that's the use of solitary confinement. I know it's used often when there aren't many other options for punishment within a prison, but on the other hand, how can you make that work better and can prevent abuses of that?
So there's basically two ideas. One is, nobody in the country is getting rid of solitary confinement because you have to protect other inmates from their most dangerous colleagues there. And there are some very dangerous people that hurt other inmates. You got to put them by themselves. You can't inflict those people on other people. But two ideas. Number one, give them programming. Give them the kind of treatment and interaction that's going to calm them down, connect them better to reality, build their coping skills, so that they don't just end up angrier and angrier and less able to interact in any other way than through violence. Number one. Number two, if they've made progress, get them out of solitary. If you can, don't keep them there for years and years. If they have made some progress, get them back. So those are the two main ideas, and how you implement that varies across systems. And we have a certain framework in Massachusetts. We're trying to work within that framework, but we think we're going to make progress on both of those ideas.
Take a look at the larger picture, because you've got a population here that gets locked up. The great majority is going to come back to the community, and a significant percentage of that has some serious mental illness problems. Does this legislation address that in some way?
This doesn't change the serious mental illness concept. That serious mental illness word is a term of art, and we've had some interesting dances around just how you work that word into the legal framework. But everybody agrees that people who have serious mental illness should get treatment, whether that's in prison or elsewhere. So the most truly serious mentally ill, one of the key things is to keep them entirely out of solitary. We don't want them in solitary because they rapidly unravel in the solitary environment. You want to give them that we've done pretty well in Massachusetts with these secure treatment units, and that's where we want people with serious mental illness to go. So the word, now there's serious mental illness and there's mental illness. Serious mental illness means schizophrenia, depression, deep depression, very serious mental illness. Now there's a lot of other people who have some level of mental illness, probably you and I.
Or maybe trauma from violence too.
Trauma, all kinds of things. So there's a big spectrum. People with lesser mental health needs, we want those mental health needs to be addressed in prison and on the way out. And one of the other things, just shifting frame entirely though for a second, one of the key ideas is And this is likely to come in as an amendment because it is not before was not before my committee, so we didn't include it in the bill, is more work on mental health diversion. So when you confront an agitated person on the street, your police officer, maybe you get a social worker involved so the social worker can kind of calm them down and get them into a healthcare setting, as opposed to locking them up. And you lock them up, they get wilder and wilder, and things go in a very bad direction. So figuring out how to divert people who are having a bad day, if you will, a very bad day, and get them into a healthcare setting as opposed to a criminal justice setting.
I have to ask you about one thing that there was a lot of enthusiasm about at one time around mandatory sentencing, was to really crack down on drug dealing in school zones. And I guess we've come to realize that practically, let's say in Boston, maybe practically the whole city is a school zone.
Well, we've made huge progress on that in 2012, right? Because the school zone was defined as anything within 1,000 feet of the outer border of a school property. So that did mean the entire city. We reduced that to 300, so it no longer means the entire city. And in fact, the volume of school zone cases has gone down by about 2/3. But here's what we're repealing the school zone thing, but we're keeping in place the idea that if you sell to a minor, that should be subject to a mandatory penalty. That is a very rare event. There aren't that many minors who are really ramped up to cocaine and heroin yet. That's something people do in their very late teens or more likely their 20s. So this idea of pushers handing heroin to kids through the fence, that just doesn't happen in any volume at all. But if it ever does, we'll punish that very severely.
Thank you very much for being with us.
All right, thank you.
State Senator William Brownsberger. We'll have more news in just a moment.